The Federal and Devaki Specialty Hospital jointly present the Madurai Marathon 2024 Run for Health on Sunday, October 20th, 2024. Entry is free for all.
Hello and welcome to the Federal. Today, in a landmark judgment, the Supreme Court upheld constitutional validity of Section 6A of the Citizenship Act. This essentially means the special provision made to determine an illegal migrant or a foreigner in Assam as per the Assam Accord of 1985 will remain unchanged. The accord set a cut-off date of March 25, 1971 for determining foreigners in Assam. This date was challenged in the court. Many, including the state's ruling BJP, have been saying the date should be pushed back to 1951. Now, to discuss the larger ramification of the verdict, we have with us senior advocate from Assam, Mr. Shishir Dey. Mr. Dey has also served as a member of a foreigners tribunal. So who can be better than him to lend perspective to issues of foreigners and illegal migrants? And so welcome to the show, Mr. Dey. To begin with, how do you see the verdict? What will be its impact on the crucial issue of illegal migrants in Assam?
Thank you for talking with me. Actually, as per this verdict, there is nothing special. Since 1985, this is the law and it is being implemented in force in Assam. Foreigners tribunals uses this 6A to determine the foreigners or Indians. Anybody is coming before foreigners tribunal has been taking shelter of 6A if eligible. So this there is nothing special. Some people of late, after many decades, they challenged the constitutional validity. So this was only for a challenge, only for a litigation. What purpose they had, I don't know. But to me, it has no significance because it was expected. It is already in force in Assam. So there is nothing so special Supreme Court has done. Supreme Court has just said the law is valid and it is in force since before, long before.
The apex court in its verdict also stated that the direction issued in the Sarvananda Sonowal judgment to detect and deport illegal migrants should be implemented. So does it mean that this is an indirect pressure on the government to complete the NRC process, which the Assam government has put on back burner?
Actually, this case is related to NRC case also. It was tagged together. But in the operative part, there is no direction directly regarding NRC. But the Sarvananda Sonowal Supreme Court has stated that the foreigners who came after the cutoff date from Bangladesh or from wherever, they should be detected and deported. That is, this foreigners tribunal system should be implemented effectively. So some numbers of foreigners tribunals increased, some measures were taken, but now again Supreme Court says these were not effective steps because these were not doing their job properly, or in terms of number of cases pending and number of years functioning of the tribunal. They collected some data from government and they found it is inadequate or not proper. So they pressurized government that if foreigners issue is a burning issue in Assam, if lakhs of foreigners are coming, complaint is like that, then government is not doing enough as per the need, as per Supreme Court. So they said foreigners tribunal system should be more effective. And to the NRC, they did not say any word in the operative part. In other part, they have discussed. I could not go through all this yet. But in operative part, nothing about NRC.
No, but when it's said that foreigners should be, detected and deported, so what is the NRC is the only means through which the foreigners can be detected and deported, isn't it?
No, NRC means to record the Indians, to enlist the Indian citizens. It is indirectly enlisting Indian means separating foreigners. So main primary purpose of NRC is detecting, recording Indians. In Assam, it has come with a reverse effect, that is identifying foreigners. Campaign is like that. So what Supreme Court said, detecting and deporting foreigners, Supreme Court means referred to Sarvananda Sonowal. So that means this foreigners tribunal system, which was in effect from before. I think they carefully avoided NRC, and they said to place the case before some appropriate bench for further direction. So NRC matter, they still kept. There is a pressure on government. Some people of the Assamese chauvinist people, a section, they wanted this 71 to be back to 51 or something. So because of that pressure, government to some extent, because of that pressure, government kept the NRC hanging. Now there is no doubt remains whether 51 should be the date of foreigners becoming Indian or 71. That doubt has been cleared. So now there is nothing remains. Only thing government can do, can detect and deport only post 71 migrants, not others. And in NRC also, since it is based on 71, so there is no doubt remains whether it should be implemented or not. Legally, there is no withheld. NRC is not withheld legally. Only the next step is kept withheld. That or two unofficially. No official declaration that NRC will be kept in hold. So there will be some effect in NRC. Now, in foreigners tribunal, only nearly 1 lakh, less than 1 lakh cases pending. And since a person is in the NRC process, no fresh foreigners tribunal cases can be done, I think, because those who applied in NRC, there is a detection process. They will automatically, they themselves will come to the foreigners tribunal by appeals, by filing appeals. So this foreigners tribunal matter only to limited persons, and NRC will be to a larger section of persons. And one who applied for NRC, whether name included or not, no fresh foreigners case can be done. Otherwise, a person will be prosecuted twice. Because once he will come through appeal, and one government can file foreigners tribunal case. So two cannot run simultaneously. Foreigners cases already those filed and pending, that will run. And if anybody is found not applied for NRC, so he is not coming under NRC process, that government can detect now also. Maybe one person came last year, or maybe came before but did not apply for NRC. That can be prosecuted by foreigners tribunal. But those are applicants of NRC. To my understanding, they cannot be referred to foreigners tribunal afresh separately by government.
Okay. So you also said that foreigners tribunals are not very effective in Assam. So what is the reason why it's not functioning properly?
When number of foreigners tribunal increased in 2015, it was 36 earlier. Then 64 was added, and number increased to 100 foreigners tribunal. That 100 foreigners tribunal functioned well for a few years. Then later, I don't know the reason, foreigners tribunal in terms of number of disposals, if we look to the government data also, this number of disposals reduced. So again, in the 200 more foreigners tribunals were constituted, but without any office, only members appointed, and then after 3 years discontinued, because the government said there is no need because NRC appeals have not come in yet. So if, as and when, or if NRC appeals comes, they will reconsider reappointing the members. So I was also one of them. So in this way, it is government's will only. Government is not willing to dispose of the 1 lakh, nearly 1 lakh cases pending in foreigners tribunal. And these are running very slowly. And foreigners tribunal, those appeal cases will come from NRC excluded. Another 20 lakhs, about 20 lakhs. But from them, some people will go through CA. They may not appeal. They may accept that they are not eligible for NRC. So they applied
So
for CA,
they
or
may
they will
apply through Citizenship Amendment Act.
Yes, apply for citizenship. They apply for citizenship through Citizenship Amendment Act 19. So number may be reduced from 20 around 19-20 lakhs. It may reduce up to 15 lakh, but not less than 10 lakhs in any way.
Okay.
So these appeals will come in once rejection slips, rejection orders, copy of rejection orders starts distributed, and people get rejection orders. Then they are eligible for appeal. When they will file appeal, automatically large number of appeals will come. And I hope again some need will be arisen. And due to this Supreme Court direction also, more foreigners tribunal may be functioning to dispose of the appeal cases. Though Supreme Court is silent in this matter yet.
Okay, but many are saying this cutoff date is discriminatory as it singles out Assam. So what is your take on that?
Discriminatory. To whom it is discriminating? Some people, they are foreigners. Government is giving them some amnesty based on some cutoff year. While giving them benefit to someone, they are not discriminating to someone by not giving. And in Assam Accord, it was given only up to a date those who came to Assam and settled permanently, irrespective of caste, creed, or religion or language. Only thing is they have come from specified territory, that is present Bangladesh area, before 71, 24th March, 25th March.
Yeah,
so there is, I think there is not.
But don't you think that this also contradict with CA, because CA has now set another date, that is 2014. So those who have come until 2014 can now apply for citizenship, provided they are Hindus, Buddhists, and Jains, and from some of those Indic religious community. So
Yes.
Isn't it
Actually,
contradictory?
No, not at all contradictory. Because when 6A was implemented or passed in 85, till then, those who came after 71, they were eligible to apply for citizenship by application. Up to 71, there was no need of any application or any process. It was simple as just one person came and settled, became citizen. But after 71, it is since before in the Citizenship Act, Section 5, Section 6, they were not excluded. Till 2003, Section 5 and 6 were in force. Anybody could apply for citizenship. Any illegal migrant also could apply. It is in 2003 amendment made in the Atal Bihari Vajpayee government. And that, due to that amendment, illegal migrants were barred from application. And now this bar is removed for a limited person based on religion and based on another cutoff date. Thereafter also, even yesterday or even in 2015, if someone comes, even if it is not Hindu, not Buddhist, not if Muslim also, if comes with passport and visa and stays legally, after 5 years can apply for citizenship. Whether it will be granted or not, it is always prerogative of the central government or union government. But application is not bad. It was never bad before or after, or even now, not bad. So there is no contradiction.
The Federal and Devaki Specialty Hospital jointly present the Madurai Marathon 2024 Run for Health on Sunday, October 20th, 2024. Entry is free for all.